So, children law and what we think about when we think about children. So, your law, as I said right at the beginning, is basically, or is quite close to Scottish law in terms of the statute that you created in 2008. So it is similar to the Children Act, but if you're looking at English law, be careful because it is different. It's also very similar to Scottish law, but not identical. So again, be a little bit careful. But what all of these bits of law tried to do was to create a one-stop shop for everything to do with kids. Where it comes from, and basically it's the same ethos that underpins the Children Act, which was 1989 in England. What they wanted to do was to make it very clear that it's up to parents to parent their children. That's their job, their problem. But that the state should support them in doing that. It wanted to create a mechanism for making it clear what the principles are that underpin British law in relation to kids. And there are a number of principles that have been there since medieval times. And they wanted to put those on a statutory footing. So when we're looking at kids, this is what matters to us. And they wanted a practical framework for sorting out problems between adults who can't agree what should happen with a kid. Okay. And those are disputes between adults, classically family members, where a child should live, whether it should have an inoculation or not, whether it should go to boarding school, whether it should go on holiday, whether it should be spending contact time with dad or not. Those kinds of disputes between family members. Should a child live with gran? All that kind of stuff. See gran. We tend to call those private law matters. So if you hear someone going on about private law children, that's what we mean. We're talking about disputes between family members around arrangements for kids. Okay. But the other thing that the law wanted to do as a significant aim was to say, okay, the other thing we want to be very clear about is that the state should only interfere in family life where it has to. So we're going to say parenting is the job of parents, supported by the state, but the state should only be interfering where it is justified. And the reason that's important is because human rights has become even more important since the Human Rights Act came in England. You have the human rights law here, which is, I think, to all intents and purposes, identical. That identifies that people have a right to family life. Okay? The right to enjoy a normal, private family life. So what the law said was, we are going to set out pretty much exclusively when the state can interfere with your kids. We are going to build in protections for two reasons. One, to make sure that adults with children are protected, that family life is protected from inappropriate interference. But secondly, child protection, because we want kids to be okay. So what we've ended up with is a piece of legislation which I think is great, which says, okay, we're going to say that there are some principles that we hold dear when it comes to kids. These are things which are core to our understanding of what it is, or the importance of children and the fact that they are vulnerable and special in some way. And society holds them dear, and we are going to set out overarching principles. And those principles are going to apply to any situation where we're talking about bringing up kids, pretty much. And within that, we're going to give the court powers and duties and responsibilities which enable it to deal with private law, which is family disputes, and public law, which is disputes with the state. And we're going to give judges these principles laid down in stone, and we are going to give them a smorgasbord, a toolkit of powers, orders they can make. Some of them, those powers, they can only exercise in private law proceedings. Some of them, they can only exercise in public law proceedings, and some of them you can chop and change between the two. So a judge can sometimes pick and choose. If he's sitting in a public law case, he can sometimes say, I fancy having a look at that kind of order, or I fancy having a look at one of those. The idea being that a judge should be able to find a solution in law which meets the needs of any child in any set of circumstances. That's how much of a one-stop shop it is. So it gives judges principles, but also a massive amount of discretion, and a variety of orders that they can pick and choose from. And it also gives them guidance about how they go about making these decisions. So for the purposes of this very short sort of 5 or 10-minute introduction to family law, from a Guernsey point of view, just grasp a moment the fact that there are principles which apply to everything. And there are some concepts which are quite important, which underpin the law as well. We'll be talking about the welfare principle and what that means. Why it is that the welfare of the child is paramount, why it's so important, and what it means in practice. We'll be talking about something called parental responsibility, which sounds quite simple but isn't in a way, which defines when people have to be consulted, when people have a say, when people have a duty towards children. Okay. So parental responsibility is one of those big concepts that applies to the law, whether we're looking at private law or whether we're looking at public. So these principles are literally an umbrella, which you have to grasp in order to look at either of these things. Okay. And you'll understand that although there is a bit of a link between them, generally family disputes are private law orders and public disputes are public because they involve the state. This is the state stepping in. The other thing it does, which is great, and we don't have this in Jersey, is it gives the public, the state, a duty towards children, not just to keep them safe, which is child protection, public law, but also to fulfil the needs of children. Quite often we call them children in need, children who need the support of the state, care leavers, people who've been in care. If you are in care. Okay, so your law tries to take care of that as well. So the idea is what we've created is a bubble which should be able to deal with pretty much any situation involved. These principles, some of them are ancient, they've developed since medieval times in Britain. They're quite unusual within the world. The way that we hold children somehow more special than adults. For some reason is cross British thing in some ways. But the law actually enables the court to deal with all of these situations. Okay, and tells them how to do it. It's a brilliant thing. It's a lovely thing. The British law is great, but I think the law is fine as well. One of the difficulties that you have in Guernsey is that not many of the, I don't know how many cases there are, but not many of them get reported. There is not a massive body of case law. Okay. So sometimes we can look at English case law, and sometimes there are a couple of Scottish cases out there about various things. But there are not many Guernsey cases which actually tell us academically how the Guernsey courts approach this. How common is it for you to get disputes between parents about kids? Quite common, I think. Yeah. And does it quite often go to litigation?
I think more than it gets negotiated.
Really? Okay. We don't have that many then actually in court in Jersey. I mean, a lot of cases involve arguments about it. Don't have that much litigation. We do have an awful lot of public law.
Might start off and then be able to put on the consent order.
Oh yeah, very often there's that along the way. Yeah, and that's good. What we are finding is that in our private law disputes, the problems are getting nastier. So whereas 15 years ago, I might have been dealing with a case where Dad wanted an extra night, or Dad wanted to change the handover arrangements for the car park, whatever. We're now getting serious welfare issues coming up in family disputes. So we're getting mum saying Dad sexually abused the children, or we're getting Dad saying mum's a nutter, or we're getting mum saying Dad drinks, or whatever. But those issues that make us worry are cropping up more than they used to in private. They're getting harder to deal with. Domestic violence is a real thing. We have an awful lot of public law, so we have an awful lot of kids involved in care proceedings. Care proceedings here, they call it something slightly different, where there's a potential for them to be removed from their families. This is in particular where your law is a bit more like Scottish law. So if you're looking at English textbooks when you come to do your revision, you'll see them, don't panic when you see them talking about care orders and supervision orders, things like that. The effect of your law is similar, but it is different because they've adopted a more Scottish system, so the terminology. Don't panic, you're not doing anything right because your law is different to the law of England and so it needs different terminology. And what Guernsey did was it actually set up new tribunals or courts to deal with this, unusually so. So you've got a tribunal that will sit to deal with perhaps the lower level concerns in relation to kids. Staff design standard by laymen, no lawyers at all, who will decide when families need some extra assistance in order to stay together. And you have a tribunal that will decide cases where it's more likely that children are going to be permanently moved from their families. In those cases are brought by the state, they're brought by the department who is seeking to care for the child. And that leads you into thinking about things like adoption, because sometimes children will be permanently removed from home and they are of an age where the local authority, the department in your case, is going to be saying, we think the child should be adopted. You should have a forever family, the phrase I like to use. We're going to give this child a forever family. That requires an application for adoption, often contested by the parents, and severs completely their ties with their birth family. Described by one judge as being the most draconian order a British court could make is the death penalty, because it removes a child from the family for life. Severs that legal relationship, they are no longer their parents. Very sad cases, quite serious. And devastating for parents. So big responsibilities involved in this kind of work, particularly for the public law arena. In Jersey, we have a children panel, which means that you have to have done special training to be able to do this work, public law work. We have to have undertaken 3 or 4 day course. We have to have had special legal training. We have to have passed an interview with a panel of court and our state, the equivalent of our safeguarding service, and have to go through a 2-stage interview test, and we have to have special training to do this work. And that's known as children panel. And even within the children panel, only the best performers within that panel are allowed to represent children, because it may be that children have their own at least in Jersey.
We very often have a advocate appointed to the child.
Okay. In Jersey, they would be one of, I think we've got 11 or 12 advocates qualified to represent children.
Oh, so it's quite a specialist
Yeah, it's very
accreditation.
special. But Jersey, as you know, Brad, has a bit of a history when it comes to child abuse cases. They do try very hard to get it right. So you've got 11 or 12 on the panel who can represent children and parents. Okay, so that's the basics of child law, actually. And understanding child law is, the art of it is not panicking. Because some of these principles and concepts, when you first look at them, are a bit weird. They're a bit counterintuitive. You sort of, well, what is parental responsibility? I don't really know, and how do I get it? And can I ever lose it? But once you actually start thinking about it as being there for a purpose, actually, same with private law, family disputes. It's all about what's best for the kid. And public law is all about in what circumstances is life bad enough for the state to walk in and take a child. Any questions about that? You're looking distressed and confused.
That's my default position.
Oh, you've got his own head. So try not to be scared of it. If you remember what the law is trying to achieve, is actually, I think, used to be logical. The one downside from my point of view in terms of teaching you guys is that I can't give you oceans of case law which tell me how the Guernsey court applies this stuff, because it's not really reported. And that is for a very good reason, I imagine. I don't know, because I haven't had that conversation with your judges. But I suspect that Guernsey is such a small community, it's so easy to identify people here from detailed judgments. Even if you anonymise them, you know who they are. We have that problem a bit in Jersey. But more so here, that the court is reluctant to report cases sometimes. I wonder if that's what happens. Or it could mean you don't have any public law cases and your society's lovely.
We have them.
In which case I suspect they're just not being widely reported. Which I can understand, but it does make it slightly difficult to know how the judges are applying your law. But that's fine. Okay. So that's a whistle-stop introduction. Does that make sense? Have you had a chance to read through the child section? Don't worry if you haven't.
I have read through it.
You have. What were your initial thoughts, because you work with it on a day-to-day basis, but what were your initial thoughts? On the children aspect of it, the children section of the course, was it horror and sort of, oh my God, it doesn't make sense, it's a nightmare, or a little bit, yeah. People can be quite scared of it, don't be. It's okay. It just takes a little bit of, it's different for us because we work with it, but when you don't work with it, it just takes a little bit of telling yourself not to panic and just working through what the actual principles are and understanding that it's a one-stop shop, so it's all designed to fit together. And if you understand it's like a jigsaw puzzle, it's much better. Sorry?
I do think it is how it is.
Yeah.
Then the convener
Yeah.
and the court itself, and then you've got three different trying to do the same thing. But I find that one.
Yeah, I think it's one of the things that has struck me from your law is that there is the potential for the lower court, so the tribunal, because it's made up of lay people and it's actually applying some quite tricky concepts, really. And I don't know how much supervision of it there is. It just seems to me there is the potential for it to go horribly wrong.
One instance where the tribunal's decision, the court then can't go against it.
It's,
I think in the magistrate.
yeah, it is quite. The problem with when you start out with any set of children proceedings is that these cases quickly become self-fulfilling prophecies. So if a judge makes an order early on that has a profound impact on the family, whether to leave a child in its home or to remove a child is the classic one, that has a profound impact on the whole of the litigation. Where a child has been removed, it is really hard work to ever get it back. And where a child is left in the home, the onus is really on the state to prove that that's not the right place for it to stay, if I can put it that way, because you've already proven that things aren't so desperately awful that the child needs to be removed right now. So the decisions that are made early on can have a really profound impact on the shape of the whole litigation. If you have a child, particularly a young child, who isn't seeing much of its mum, classically, and quite often when children aren't living at home, when they've been removed, they might have contact a few times a week if you're lucky, but it could be as little as once a week. Sometimes with dads, you can go long periods without them seeing their child for all kinds of reasons while they do assessments of everything under the sun. And that's fine. But children can very quickly lose that connection with their parents. So very quickly you can reach a situation where actually it's very difficult to put the children back home because they've lost that attachment to their mum or dad and quite often have formed an attachment to someone else. And you see that in private law proceedings and public law proceedings. If you are acting for a dad who is not seeing his child, you need to do something really quickly, because the longer a parent goes without seeing their child, the harder it is to ever establish contact. So decisions that are made at early stages or put off have a really important impact on cases. And there was one case I saw where the tribunal had effectively put conditions around a community parenting order, which almost looked a lot like a care order. The child wasn't meant to live in certain places. The child was meant to live with certain people and not with others. And I just thought that's an awful lot of power for a lay tribunal to have, to effectively separate a family. And I wondered if that was really the intention behind their role, which seemed to me to be largely supportive, you know, that they should be there working to keep kids at home rather than perhaps more draconian remedies which you'd normally associate with a magistrate in England or with the Royal Court, perhaps in Jersey. So I think it is difficult for me to tell how much power the tribunal have and what the checks and balances are. I know the convener zone and safeguarding services, but legally they have quite a lot of power.
And you wouldn't necessarily see it as an advocate because you're not supposed to take your advocate to the tribunal.
And that's what I find scary. These are where you've got a lay tribunal deciding matters that could either keep a child at home, which is an important thing to be doing, or which may drift into areas where there are restrictions around those children being at home. That to me is a legal process because that's the way I've been brought up. It's a proper legal process and it's hard law, serious judges, preferably in the High Court, and you know, doing a serious job with serious lawyers addressing them. Highly trained lawyers, lawyers who have an extra level of training, even amongst family specialists. So to have that within a lay environment, so you've got lay judges who do not know the law, they will, I'm sure, know the background to the law, but they are certainly not lawyers, and parties who are not represented by lawyers in a world where clients that you are working with very often have mental health difficulties, learning difficulties, substance misuse problems. So the whole situation for them is overwhelming in the first place. And if they're dealing with it without serious, hard legal scrutiny, how much of a risk that is. But I don't know, it's difficult for me to tell from the case law because there isn't any. Particularly, I suspect the tribunal don't really produce decisions, do they? So in a way, we don't really know what they're doing. So we rely, I think Guernsey relies quite heavily on the convener. And if you've got a great convener, I'm sure it's fine. And relies quite heavily on the safeguard service, I suspect. And occasionally on cases being appealed. But a lot of your case law seems to have been a little bit of a flurry not long after the law came into force, which isn't surprising. But there's not a constant flow of authorities coming out of your courts. So what we can do is to get a really good idea of the structure, what the job of the individual courts is, because that's set out in the law itself, and it's a monster of a law, it's a massive great. It is really, really, really big, makes the children act look slim.
Yeah.
Because it designed a whole court system, it didn't just set out legislation, it designed a whole system around it. You will need to be reasonably familiar with it, because you need to know what the jurisdiction of the individual tribunals is, because that's key really to the powers and the functions that the law contains. It's quite digestible though. You can read the children law and it should make sense once you understand what it's trying to achieve, and we'll have a look at the principles and what have you. So don't be scared of it, is what I would say. At the end of the day, it is about, in private law disputes, remembering that children are at the heart of these things, and that children need relationships with everybody they love in a way that works for them. And in public law, it's about controlling the ability of the state to interfere in family life whilst protecting kids. So it's that fine balance between when you can and should step in and when you can't. And that's probably one of the hardest areas of family law, because if you get it wrong, that's when children get hurt. Who provides legal advice to your department? Is it the law officers? Yeah, and do they ever brief advocates to appear for them? Because I represent quite often the state in proceedings in Jersey, but it could be that here it's done by the law officers department.
Only the law officers.
Okay. Yeah, we have unfortunately too many cases for the law officers to do all of it.
Yeah.
Okay, that's good to know. So there's no value really to you guys as practitioners in us spending a lot of time talking about how you'd advise the department, because that's not going to crop up unless you're a law officer. Okay. So that's an introduction, and we'll start talking about some of the different tribunals and bodies when we come back after lunch. But I think if we start to have a look at the private law side of things today and some of the concepts involved in that, and then we can have a look at public law tomorrow. But the key is not to panic, it's fine. It may take a bit of time to get your head around it, but fundamentally it's fine. It's all right. You should come with a big "don't panic" written on it, like the Hitchhiker's Guide to the Galaxy. Right, now I think you should take a proper lunch hour. So if we're back at 2-ish, is that all right? And if you need to finish